Over the last decade, 5 Muslim men have been detained without charges. The tool that was used, security certificates. Joining us now for more on this tool and the security and civil liberties rights at play. In the nation's capital via Skype, Wesley Wark, visiting professor at the Graduate School of Public and International Affairs at the University of Ottawa. And with us here in studio, Sherry Aiken, professor of law at Queen's University. Graham Hudson, professor of criminology at Ryerson University. And Amar Walla, producer and director of the documentary The Secret Trial 5. And Wesley, it's good to have you on the program again from Ottawa. You three, it's good to have you here as well. Let me start by just reading this from Public Safety Canada, and then we're going to take a look at a clip from your movie. Here's what Public Safety Canada has to say about the security certificate process within the Immigration and Refugee Protection Act is not a criminal proceeding, but an immigration proceeding. The objective of the process is the removal from Canada of non-Canadians who have no legal right to be here and who pose a serious threat to Canada and Canadians. And again, pursuant to that, let's take a look at a clip from your documentary. Mo, rotate.
Initially, certificates are supposed to start with CSIS, the Canadian Security Intelligence Service, which is engaged in all sorts of investigations around individuals that it thinks might jeopardize the security of Canada.
It may begin to develop a file on somebody and come to the conclusion that someone constitutes a threat.
And then they bring that material before 2 government ministers, the Minister of Citizenship and Immigration and the Minister of Public Safety.
So CSIS shares the information with the 2 ministers who then sign off if they decide it's warranted.
Then the matter would be referred to a federal court judge, and the judge would review the secret evidence.
And it's essentially up until you get to the federal court, the person concerned has no idea that this is going on. It takes place behind closed doors.
And a judge of the federal court evaluates the dossier of intelligence. On the basis of that evaluation, will deem the security certificate to be either reasonable or unreasonable.
Okay. Who are the Secret Trial 5?
Well, the Secret Trial 5 are, as you said, 5 Muslim men who spent approximately 30 years in Canada within the Canadian prison system, but they did so without ever being charged with a crime under the security certificate process. And that's kind of how this all started for me. I was very intrigued by the idea that a person could be held for this long a period of time in Canada without being charged. And I started looking into how that's possible, and that's sort of how the film came about.
What in particular sort of pricked your interest about this subject?
I actually got to know the son of one of the detainees. His name was Mahmoud Jabala. His son's name was Ahmed. And my graduating piece from York University was actually a short film about a night early in their lives in Canada when Ahmed, as a 12-year-old, was translating for his father as CSIS operatives interrogated his father in their home. So I found that to be a very difficult thing for a 12-year-old to go to. I myself immigrated to Canada at around that age.
From?
India, actually. And I remember, even as English speakers, just how difficult it was to adapt to our new homeland. And so thinking about a new family coming to Canada, a 12-year-old boy at that age, having to go through something like that with his father, with a new government, in your home, I thought that was a very intriguing story that this family had gone through, and I felt like I needed to sort of tell that story and share that story.
Just one more follow-up here, Mark. Give us a sense of what life is like for somebody living, quote unquote, under a security certificate.
Well, currently, these are families that are living under what are now very mild house arrest conditions. So you might actually have seen them out there. You might have actually seen them with their kids. But you probably don't know. These are people living within our communities now. But these house arrest conditions started as the most dramatic in Canadian history. So these children grew up with cameras in their living rooms. They grew up without unfettered internet access, which of course for children of this generation is quite unheard of. They were followed on family outings. Couples had to go to public washrooms together because they weren't allowed to be in separate rooms.
Followed by whom?
The CBSA, which was actually the Canadian Border Services Agency, which actually tracked these men under those house arrest conditions.
Was it their cameras as well in their homes?
Yeah, it was a combination of several agencies, but the border services were in charge of sort of enforcing all of this while they were under house arrest.
Okay. Wesley Wark, let me get you in here at this point. Do the accused and their lawyers get access to all of the evidence that is against them?
No, they don't. And that's one of the controversial provisions of security certificates. The federal court judge who has to rule on security certificates gets access, of course, to all the secret intelligence. And as a result of an earlier Supreme Court ruling in 2007, the legal regime around security certificates was changed so that special advocates, as they were called, were introduced into these proceedings to provide a kind of extra layer of scrutiny of the government's evidence. But the special advocates, who are highly trained, security cleared lawyers, very experienced people, are not themselves allowed to communicate with defense counsel or with the defendant. So there is that wall in terms of the secret evidence between the people that are accused and the government who is making these accusations.
I'm going to come back to the special advocate role in all of this in just a second. Let me continue now, though, with Graham. The 5 people that we're talking about in question here, the 5 living under security certificates, we made the point off the top from the website, from the government's own website, that this whole procedure exists under immigration as opposed to criminal law. What's the distinction and why is that significant?
Well, in the criminal law process, the objective ultimately is incarceration. It's to denunciate deviations from criminal code provisions. With that comes a rigorous procedure where the rights of the accused historically have been largely protected in law, and the enforcement of that has been pretty steady. In the context of immigration, the ultimate objective is removal of an individual from Canada, which in many cases, I think specifically when you're dealing with individuals who have been labeled terrorists, leads to breaches of rights under international law to refugee status. Many times individuals who are labeled as terrorists face a substantial risk of torture upon being returned home. So the implications are somewhat similar in terms of the impact on the individual, but the procedures are very different. The procedures in the immigration context are much lighter. It's easier for the government to get the job done in that context.
Sherry, let's also clarify, because some people might be under the impression that, oh, this must be a new post-9/11 thing. In fact, these security certificates have been around since 1978.
Indeed, and even before that, the use of secret evidence and expedited procedures have been embedded in immigration laws, since at least the end of the Second World War.
Do you think it's still a useful thing for governments to have in their national security toolkit?
I do not.
Why not?
Well, it may be useful from the perspective of the government. It's absolutely a human rights tragedy from the perspective of human rights advocates in this country and obviously the people concerned. My view is we need the tool of surveillance to address security risk. We need the tools of enforcement and the criminal law to deal with people against whom there are genuine concerns. But we don't need a fast-tracked procedure that denies all the hallmarks of due process to the individuals concerned and essentially offload the problem somewhere else, because that's what removal procedures do. It doesn't actually enhance the cause of international justice. It doesn't actually keep the world any safer, because as you know, terrorism has an international dimension, right? And simply exporting the problem somewhere else does nothing to make all of us safer collectively.
Wesley Wark, do you think it's still a useful thing, these security certificates, to have in a government's national security toolbox?
Well, Steve, I've said in print that I think that it has a place deeply buried in the government's toolbox and used sparingly. And I would say used not in terrorism circumstances where the allegation is the person poses an alleged terrorist threat to Canada. It does have other kinds of uses, and we've seen those uses in terms of espionage cases. For example, a security certificate was used against a Russian spy whose cover name was Paul William Hempel, used successfully. It was also used, curiously, against Ernest Zundel, the Holocaust denier, to remove him to Germany. And in neither of those cases were there any real denunciations of the security certificate process. But in terms of using them in terrorism cases, I would agree with much of what Sharon has said, that they're an odd tool in the sense that you're ultimately, if you are able to deport someone who you find is involved in terrorism, you're simply exporting the problem elsewhere. And in reality, given Canada's commitments to international law and torture conventions and so on, we're probably never going to be able to deport people to many of the countries from which they might originally have come, countries which have abused the law and practiced torture. So we're stuck with this problem. But I would just add one cautionary note that we have to be careful to assume that there's something else better available in terms of immigration proceedings. And I would be worried, on the other hand, that insofar as security certificates are not really a fast-tracked process, as we've seen, there are other measures that can be taken under IRPA that are fast-tracked that might provide many fewer, legal routes for a suspect or a defendant to actually employ. So if we take security certificates away entirely, it opens the door to other problems, and that's something we'd have to be careful about.
Okay, before we pursue that second angle that you just mentioned, I do want to get Amar on the initial question, which is whether you think there's still a place for them in this issue.
As someone who's sort of a layperson and outside of the legal world, I don't think most Canadians would care if the government used this as a spy deportation tool. I mean, from what I've learned making this film, Canada has always had sort of a quid pro quo arrangement with other countries. If we catch your spies, we'll deport them. The problem is when a law like this exists on the books, there's always the opportunity for abuse. There's always the opportunity for it to be morphed into something. And as you saw with the detainees in our film, it morphed into an anti-terrorism tool. And as many of the panelists have said, terrorism is a crime. It's maybe the ultimate form of criminality in today's society. So how does an immigration process on top of that process really make sense? And that's my concern and my fear, is that if it exists on the books, how do we ensure that governments in the future won't use it for these purposes?
I have a quote here, Sherry, I want to put to you, and then I'm going to get you on this, Graham, but I do want to follow up on this. 2006, arguing at the Supreme Court, a federal lawyer by the name of Bernard Laprade defended the use of security certificates, saying, "National security is not something that is just desirable, it is an absolute necessity, because without it, all other rights become theoretical." He's making the argument that there is a place for them. You're making the contrary argument.
Well, I don't dispute that national security is an important, indeed compelling public objective, and I don't dispute the government's responsibility.
He goes beyond that.
Right.
He says absolute necessity.
Right. National security, right? National security is a compelling objective, but individual rights always have to be factored into the equation. National security doesn't trump all, and indeed, our Charter of Rights, the way it's framed, and in any constitutional democracy, it's framed in this manner, national security isn't the ultimate trump. Always individual rights have to be factored and weighed into the equation. So the question is, do immigration security certificates meet the appropriate balance? And unfortunately, our current Supreme Court of Canada has found the mechanism constitutional. In my view, that doesn't end the discussion. And I think this issue is going to be back before the Supreme Court of Canada. You know, it's interesting to note, the European Court of Human Rights actually found that the special advocate system in use in the UK, which the Canadian system was modeled over, doesn't meet the requirements of the European Convention.
Hold off on that because we haven't got there yet. We're going to get to the special advocate in a second. But I still want to get you, Graham, on whether or not you think this is an appropriate thing to still have in the national security toolbox.
Well, to say a couple of things, I think to the last point, one of the questions we need to ask is what kind of nation are we hoping to secure? What sorts of values do we want to aim for? If we're thinking the government in the bare minimum is simply about maintaining an objective sense or a feeling of security, to kind of use symbolic power of the police state or peace officers to project an image of security, that's one kind of nation. If we live in a democracy where the government is not only expected to provide basic peace and security, but to promote values of diversity, equality, and multiculturalism, then you have to look at security certificates in a different light. And I think to the points that have been made, there's a problem from human rights perspective, clearly from security certificates that I think attract a very, very energetic response that you don't see in other areas of immigration law. So in that sense, I think security certificates are highly problematic, but at the very least, they draw attention to a larger assemblage of national security practices and help us get the energy and mobilization together to start peering into the darker corners of the entire national security apparatus. Effectively, I think that there's a problem with security certificates and that they have not actually led to any of the end games that the government has stated as being their objectives.
So you'd get rid of them?
I very strongly think they're ineffective, they're inefficient, and they violate human rights.
Sherry, let's now pick up on that angle that a couple of you have mentioned already, this sort of extra line of defense, if you like, called the special advocate. What's their job?
Their job is to view the secret evidence that the person concerned doesn't get to see, and try to mount some kind of response to that secret evidence. The problem is the way the procedure's been set up in Canada and the very procedure that was ruled problematic in the UK, the special advocate is not permitted to go back and speak to the individual after they viewed the secret evidence without the authorization of the judge. And as a practical matter, that means there's never authorization. And so the person concerned really isn't given the basic tools to answer the government charge.
Wesley, why would that extra contact after the evidence has been seen, why would that not be permitted?
Well, the challenge here is it's a very good question, and it may ultimately in the future be one of the things that is subject to amendment in IRPA if we continue to have to deal with security certificates. But the basic challenge here that I think has to be understood is secret evidence and how secret evidence is going to be dealt with. And security certificates in certainly in terrorism cases have become almost a quasi judicial process. That special advocates get to see the secret evidence. The judge gets to see the secret evidence, but there is, as I said, a wall between those two individuals and defense counsel and the defendant. What the defendant, it's important to understand, does get to see, and what his counsel or her counsel gets to see, is a CSIS summary called the Public Intelligence Report, Security Intelligence Report, a CSIS summary of the evidence against the accused. And one, I think, frankly, and I've seen this at work because I've been a defense expert witness in 3 of the 5 security certificate cases. One of the problems is really the quality of that CSIS summary that goes to the defendant and his counsel. And in all 3 cases that I've been involved in, the quality of that public summary has been what I would regard as abysmal. And that's one of the challenges that's going to have to be faced if we continue to use this process.
The special advocate, Amar, did the Secret Trial 5, whom you chronicled in your film, did they have access to a special advocate?
They did. After 2008, when Bill C-3 was brought in, each of them was given a special advocate. I just want to, before I move on to that, part of the issue with the secret process and a one-sided process like it was even before the special advocate got in there, Wesley's mentioned a couple of times that the judge is seeing all the evidence. That actually wasn't true in a couple of the cases. Once the special advocates actually got in there, it was clear that CSIS and the government lawyers had withheld certain information from the judge in a couple of the cases. The tendency for abuse when only one side is getting to speak to the judge is actually quite high. So that's a process that we really need to question.
So the judge might have done something different, you think, if he or she had had access to all of the evidence?
Absolutely. I mean, there were questions of whether informants had failed lie detector tests, whether that information was passed on to judges. None of that was under scrutiny up until 2007, up until the special advocates got in there. The problem, if you're a special advocate, is that if you I've heard this from many lawyers, take it from what it's worth as a layperson, but communicating with your client is a big part of how you determine strategy. So if they have information and they can't go back and ask a very simple question of the person they're ostensibly representing, how are they supposed to do their jobs? I'm sure that it's helped. People within the film, Norm Boxall, the attorney from Mohammed Harkat, talked about how it's better than nothing. But is it really providing a fair process or not? That's the big question that we need to ask.
And did they find, the Secret Trial 5 in your film, did they find that this wrinkle in this, wrinkle is the wrong word, but the fact that the special advocate couldn't go back to the client in question after the evidence came forward, was that a real problem for them?
For them, it's the exact same process. Because if you look at it from the point of view of the accused, you're still completely in the dark. You don't have any more information about what's being said about you. So if you're Sophie and Mohammed Harkat, for example, recently went to the Supreme Court. It took 12 years to get there. The Supreme Court goes into a closed hearing. The special advocates go in there with them, and they come out and your case is upheld. So Mr. Harkat has no more information today than he did back then. So from the point of view of the person actually going through it, from a human rights point of view, it's still just as devastating.
I don't want to give away the ending too much here, but of the 5, a couple of them are no longer living under security certificates, is that right?
That's right. Hassan Almari in Toronto and Adil Sharkawi in Montreal won their cases in 2009. And Mr. Sharkawi actually just became a Canadian citizen. So he says that he'll take that as admission of guilt by the government. You can take that as you will, I guess.
But the other three, yes, still.
Yes, continue to live under what is now very sort of mundane house arrest. But the cases are still going on. The symbolism is still there. And the cloud of deportation is still sort of hanging over them.
Let me pick up on that. The cloud of deportation, Graham, what's the chief concern that you have about potential deportation at the end of the road?
As deportation to torture, I think, is the clear problem. I think in each case, each person named in a security certificate has, on good grounds, claimed that they would be at risk, a substantial risk of torture if returned to their home countries. Each of them comes from a country with which Canada has fairly recent formal and informal intelligence relationships with. When we kind of reflect on some of the events post 9/11, including Maher Arar, we notice that Canada has been involved in extraordinary rendition, returning people through illegal means to face torture, sometimes for the purposes of acquiring actionable intelligence. So for me, the detention, the discriminatory aspect of security certificates are the immediate concern, but always lingering in the background and getting larger and larger with each passing day is what happens once a certificate is upheld.
Well, Sherry, let me push back a little bit on this insofar as when this process was used to get Holocaust denier Ernst Zundel out of Canada back to Germany, there was no risk of him being tortured when he got back to Germany.
You know, and I put my name on a petition that was directed to the federal government complaining about the use of the security certificate procedure against Ernst Zundel, not because I didn't think Canada shouldn't deport him. Yes, we should have deported him. Yes, he needed to face justice back in his home country, which, by the way, was prepared to pursue it. But he was facing the prospect of deportation to a European state, right, which complies with human rights, which affords due process and everything else.
So not an issue there.
No, it's not an issue at all in terms of him going back, but we didn't need the security certificate procedure to send him back, right? We could have used extradition. We could have used any one of a number of other tools.
Because we had a relationship with Germany.
Indeed.
Okay.
Right? And because if there was significant evidence that Ernst Zundel actually had committed offenses, there's the criminal justice system to use. I actually think it was absurd that the government chose to use immigration security certificates in his case. And I'm certainly no fan of Ernst Zundel.
Wesley, could I get you to weigh in on the concerns that you may or may not have in the event of deportation?
I mean, it's a huge problem. First of all, I think we have to say that so far, at least, we have never seen a person who has been found in which a security certificate has been granted as reasonable. We've never seen an individual in that kind of circumstance actually deported to a country that practices torture. The problem is that you can never be absolutely certain, and a person like Mr. Harkat, for example, faces now, because of the Supreme Court ruling that upheld the constitutionality of the security certificate regime and also upheld the process by which the federal court found him to have had his security certificate issued against him in a reasonable manner. He faces deportation to Algeria. Now, Algeria has a past that is very dark and certainly full of torture and human rights abuses. It may have a future that will hold such a thing. The present, perhaps one might argue ambiguously that it wouldn't be a certain thing that he would face torture upon being deported to Algeria. But you can't tell about either the present or the future, which in essence means that I think Canada, on any reasonable grounds, won't deport people to countries like this. But it means that these individuals then ultimately face very long-term, if, as Amar says, minor conditions of house arrest. And that's not a satisfactory legal outcome.
Amar, let me follow up with you. Pick one of your five and tell us what they thought about the potential impact of deportation on their lives.
Well, I think it's important to distinguish between cases like Mr. Zundel. Every single one of the Secret Trial 5 was told they're free to go if they choose to go back to their country of origin. So,
which would be which?
Algeria, Syria, Egypt, in a couple of cases, Morocco, and none of them took the government up on that opportunity. Instead, they spent nearly 30 years in prison combined, much of that time in solitary confinement. So that should tell you something about the choice they had in front of them.
They don't want to go back.
The other part of this is that, part of the problem with the framing of this is it doesn't take into account these men's lives in Canada. Many of them, most of them were actually granted refugee status. One of them, Adil Sharkawi, was a permanent resident of Canada, which I was when I moved to this country. They had lives here, they had wives here, they had Canadian-born children in certain cases. This is not a case of someone sneaking in, getting caught right away, and us trying to get rid of them. These are people that built lives in Canada. So asking them to go back is not an easy thing to ask of somebody who's, had children who were born in Canada.
Graham, I gather, though, that part of the reason that the government has opted to go to this new process, special advocate, security certificates, etc., was that this was supposed to be a quick and efficient way of dealing with these most problematic cases. Has it turned out to be that way?
Certainly not. If you read Section 83 of the Immigration and Refugee Protection Act, the very first subsection states that the judge shall ensure that the proceedings are conducted as informally and expeditiously as the circumstances warrant, and that has simply not been realized. There are a couple of reasons for that. Largely it's to do with parallel secret proceedings and arguments about what evidence is fairly classified versus what evidence can safely be disclosed. But also at the same time, we've got numerous charter challenges going on. And if the claimant successfully invokes a charter right, then past proceedings may have to be recommenced. Certainly after the 2007 Sharkawi decision, security certificates had to be reissued and the government had to start from square one over again. So they have certainly not been informally and expeditiously conducted.
Not quick, not efficient.
Not at the fault of the judges. It's the nature of the proceedings. It's the volume of the intelligence. There's thousands and thousands of pages of intelligence. The complexity of the case files, the nature of the charter issues. It's impossible for them to be done quickly.
Sherry, do we have any sense of how many people in the country today are living under security certificate situations?
Just a handful. Although it does deserve to be mentioned that certainly in the aftermath of the first Supreme Court decision on the constitutionality of the security certificate regime, the government has been invoking inadmissibility procedures far more commonly. Now, those also provide for the opportunity of secret evidence. The individuals concerned may have access to a special advocate, but not necessarily as of right. And there's a similar sense that there's a fast track to removal. The only difference is that unlike a security certificate procedure, there is a further right of judicial review. So it's not, one kick at the can and you're out. In that sense, it's slightly better from a due process perspective.
So if it's not quick and efficient, what's the average length of time each case seems to take? I mean, it's years,
Yeah,
right?
Years.
Wesley, tell me if I've got this right. I think I read that since the process was amended in 2008, the government, which has been the conservative government ever since then, has not issued any new security certificates. Is that correct?
That's absolutely right, Steve.
And if that's the case, does that suggest that even the government thinks that this process is somehow not working?
I think that's the logical conclusion we should arrive at. It may be the fact that the government is waiting for a case to come their way in which they feel that security certificates would be appropriate. But I think that the government has learned a number of lessons from the security certificate process that it's imposed in terrorism cases. And some of these lessons we've talked about: the length of the proceedings, the cost of the proceedings, the controversial nature of the proceedings, frankly, the bad political optics around the proceedings, which are regarded by many people as simply being an unfair judicial process, whether or not the Supreme Court finds that they have a reasonable degree of fairness involved. To all of that list, I would add something that is not necessarily so visible unless you've been closely involved in these cases, which is the question of proportionality. And that is that, in my view, certainly, we should not use security certificates in terrorism or other proceedings unless we're convinced that the threat posed by these individuals that you're going to impose these proceedings on is really a high-level, serious threat. And I don't think that in the terrorism proceedings we've seen under security certificates so far, that proportionality instrument or proportionality judgment has been used. And it's important to say that there is nothing in the Immigration and Refugee Protection Act that imposes any kind of proportionality measure in terms of the nature of the threat these individuals pose. So you can have a security certificate imposed on you for a wide range of fairly generally defined offenses, whether terrorism or otherwise. They have not been used in Canada, I would say, against people that we would need to regard as kind of high-level, immediate national security threats.
Okay, with just a few minutes left to go here, let's put one more thing on the table. Here's a quote from the University of Toronto law prof Kent Roach, whom I'm assuming you guys all know. He's been on this program a number of times. He writes, "The creation of sweeping new terrorism offenses after 9/11 has blurred the traditional distinctions between intelligence and evidence. Such new offenses reflect an intelligence mindset that focuses on threats, risk, associations, and suspicion, as opposed to an evidence or criminal law mindset that focuses on acts, accomplices, and guilt." Sherry, what's your view on that?
I agree with that. The only thing I would add is that embedded in immigration law is this notion that you're guilty if there are reasonable grounds to believe you are currently a member of a terrorist organization, for example, may have been in the past or could be in the future. And that notion of sort of forward and backward looking risk is the heart of the problem. And that's been in place for a very long time.
Amari, your view on that comment?
I think that that's very accurate. I think that information and evidence are two very different things. And I think that evidence has to withstand a certain level of scrutiny by the person being accused. And I think that that has sort of like gone by the wayside in these cases. No matter how much protection there is in terms of other people seeing the evidence, there is no substitute for a person being able to know exactly what they're accused of themselves. So that's my feeling about the new provisions, is that they don't actually provide any further clarity to the named person.
Do they, though, Graham, reflect the fact that we're more frightened nowadays? We're more frightened because, well, we've seen terrorism in this lifetime in a way we haven't in the past.
I suppose there's an element of truth to that. Certainly the events recently in Ottawa have been cast as a terrorist act, though there's quite a lot of debate about that. And immediately following this, we see legislative changes being proposed, one of them being to extend to CSIS informants police informer privilege. And so kind of coming back to Kent Roach's point, one of the difficulties with fusing intelligence and evidence is, in addition to the human rights concerns, is the implications that has on the success rate of prosecutions. If you look back at the Air India prosecutions, for example, it was one of the linchpins, one of the reasons why those prosecutions were unsuccessful was because of problems between RCMP and CSIS in terms of exchanging information, anonymity, the inability of intelligence informants to testify in a court of law. All of these problems that we have learned to deal with legally in the intelligence community, when you transplant them into the criminal context, we start to see that much of the evidence that the government collects, even if it's barely evidence, is either inadmissible or will be deemed to be unreliable. Okay. So I feel that in addition to the human rights impacts of the fusion of intelligence and evidence, we're going to see also a lower success rate when we actually use criminal proceedings to start to go after alleged terrorists.
Thanks for your help on this, everybody. A complicated subject that I think is a lot clearer now thanks to your visit to our studio today. Wesley Wark, thanks for being there via Skype in the nation's capital at the University of Ottawa. We're always grateful for your time on this program. Amar Walla, The Secret Trial 5. Where can we see that doc, incidentally?
You can actually visit our website, secrettrial5.com, for the upcoming dates.
Perfect. Okay. Sherry Aiken, Professor of Law, Queen's University. Graham Hudson, Professor of Criminology, Ryerson University. Thanks all for being on the program tonight. Thank you.
Support Ontario's public television. Donate at tvo.org.